Mr. Clerk, will you call the next case, please?
Nona G. Rogers v. Michael L. Rogers.
May it please the court, my name is Franklin Chansey. I'm a member of the Bradley County Bar. I'd like to reserve 3 minutes, please.
3 minutes. Mm-hmm.
Your Honor, we appeal from a trial court's decision dividing the marital assets of two parties who were married for 56 years at the time of the divorce in this case. And at the time of the divorce, the wife was 72 years old and the husband was 76. Specifically, we contend primarily that the trial court erred when it classified certain assets as the wife's separate property rather than a part of the marital estate. As the court's aware, trial courts are charged by statute with making an equitable division of marital property. The first consideration that the court has to undertake is to classify the existing property in order to determine what the marital estate is, such that it can be divided in an equitable fashion. Typically, under Tennessee law, property that is acquired during the marriage is presumed to be part of the marital estate. It can, however, separate property can become part of the marital estate if it is jointly titled with marital assets, gifted to the marital estate, or utilized to service the marriage. And in this case, we think that those are precisely the doctrines that apply to the assets at issue here. In this particular case, in roughly 2016, the wife received a payment from her mother of $134,173.57. And then approximately 10 months later, she received an inheritance from her mother of $41,000.
This was after her mother passed, I assume, inheritance. Is that correct? Mm-hmm.
Yes, the first one, the mother was clearly living at the time the funds were transmitted to the wife, and the second one was after her death. Mm-hmm. It was 5 years later before the divorce was filed in this case. And the reason that's important is because of what happened to the money over that 4 to 5 year period. And that's the central issue that's before the court today. During the entirety of this 56-year marriage, up until the filing of the divorce, the parties pooled all of their funds into a single bank account. Paychecks, Social Security checks, TCRS retirement funds, pension payments. They paid all of their bills, their obligations out of this single fund. And that happened throughout the entirety of the marriage. Both parties had access to that money on an unrestricted basis. Now, after this property was received by the wife, she took it and she had it deposited into this single joint bank account along with other marital funds. It was not segregated in any way. After it had been deposited, the parties purchased an investment annuity in both of their names that exceeded the amount of the $134,000 one. They added another $15,000 to it, making a $150,000 purchase of this annuity, where it stayed for 5 years before it was withdrawn. When it was withdrawn, it was first put back into the marital joint account. So the facts are that this potentially separate fund was completely treated as a marital asset for at least 5 years. Now, unfortunately, tragedy struck this marriage. At age 73, a granddaughter of my client, an adult granddaughter, made an allegation that my client had sexually assaulted her while she was asleep. There have been no prior allegations of any sort like that throughout this man's life, no criminal involvement. The wife indicated that they had a wonderful marriage up until this point. But this broke this family, this allegation. I was struck by the wife's testimony at trial. It was on page 116 of the trial transcript. Her counsel asked her this question: in your wildest imagination, when you put that in the joint account, would you have ever thought that your husband would do something like you described today? And her answer was no, never. Why is that important? Well, because the burden is on the wife to overcome a presumption that this is marital property. She has the burden of establishing by a preponderance of the evidence that this was intended to be kept as her separate property. I would say to the court reviewing the record that there's no evidence at all of any intent by the wife to keep it as her separate property. At one point, she said early on that they chose an annuity they could invade because they might need it to help take care of her mother. Well, her mother passed away less than a year later, and it stayed in that joint investment that they could have taken out and segregated. But no effort was made to do that. So as a result of this, the wife took out some roughly $200,000 from this joint account immediately prior to the separation in this case. And the trial court, without really making any findings that I can find, designated this as her separate property. And we respectfully suggest to the court that that completely muddies the water about what commingling and transmutation actually means in Tennessee. And this is important because it has a regular occurrence in trial courts. And
Okay, I think we have a couple of questions here.
yes.
The money wasn't actually ever spent on anything, was it? It remained in the account, and in the annuity.
That's correct. It came out, though, but it came out with the additional funds that were part of pre-existing.
I understand that. It was joined along with, I'm saying this money wasn't used to buy an asset that was then sold or anything like that.
Well, no, the annuity would be an
Okay.
asset that was
I meant like a
purchased.
physical
Yes,
anything.
that's
Okay.
correct, Your Honor.
All right.
But our objection is that the court completely treated that as separate property, and that has a dramatic impact on what's an equitable division in this case. It reduced the size of the marital estate. It changes the wife receiving about 60% of the marital estate to almost 69%, which is a pretty substantial difference for people in their 70s. We have a second issue, but it relates back to the first. The court made an alimony in futuro award. I'm sorry?
Excuse me, counsel, for interrupting. Digressing back to equitable division of marital property and separate property. It's my understanding one of the positions the appellee has taken is that the funds were traceable. Can you address that, please?
Well, I think in theory, any time that you take separate property and put them in an investment, you could argue that they're traceable, but there has to be, under the law, an intent that the items be treated as separate property. And that's what's missing in the record here. I agree with you that it's very easy to say, well, she got $136,000, and that's traceable. But the reality is there was never an intent that this was going to be treated separately because these people never expected that they would have any marital difficulties.
Did the trial court make any determinations with regard to intent?
Not that I can find, Your Honor, and that is part of the issue here.
Did the trial court make any credibility determinations?
I didn't find anything about that.
Was there any testimony presented that any time during this period of time that she made any declarations to the point of what's mine is yours and we're all in this together, anything of that nature?
No, Your Honor. All I can tell the court from the record is that they combined everything in their lives into this single location.
At the time she made the withdrawal she just made the withdrawal unilaterally. She did not
That's correct.
consult with him.
That's
anything like
correct,
that.
Your Honor. And each of them had unrestricted access to this fund. There's nothing that prevented her from doing that.
Did he ever make any type of withdrawal from these funds?
There was some evidence
the proof
that
that was presented.
there was some evidence that post-divorce that he took some of the funds and put it in an annuity, but it was still treated as marital
Post-divorce.
property, though.
Okay, that was post-divorce.
So I find no evidence in the record where there had ever been a discussion that this is her property. And again, her
Some
testimony, I think,
you referred to about she wanted to make sure that some of this money was available if needed for her mother's
yeah.
care. or
And
something
so,
of that
and so
nature.
what the wife testified to at the trial was that the husband wanted to put it in one kind of annuity, and she was uncomfortable with that because she might need to access it for her mother's benefit. So they chose a different annuity where there wouldn't be a penalty if they had to take it out, a lesser interest rate, but it made it accessible if that should come up. Which also means that she could have gone and taken it out for the 3 years following that if she wanted to. She made no effort to do that. She left it in the joint funds. And more tellingly, when that annuity matured, she put it back in the joint account. So
Each time the withdrawals were made or the transfers were made, were they made unilaterally? I'm going to use it for this, I'm going to put it aside for that, or were they made jointly?
no, Your Honor, these unfortunate allegations got made for my client, and shortly thereafter, she withdrew the big chunk of it, and then she came back a couple months later and took another chunk. So there's 2 withdrawals that we're complaining about, and those are in trial exhibits in the case. We have a second issue, which I will just reserve for my rebuttal time, regarding alimony in futuro, and the effect that this division of property has on that.
Thank you. You do have your rebuttal time. Yes, sir.
Good afternoon. I'm Randy Sellers, the Bradley County Bar. It's good to be with you today. I represent Ms. Nona Rogers. First of all, to answer a couple of questions that Your Honors had, I want to clear up a couple of, I guess, innocuous misstatements about who did what and when. And the first one would be that the check from the mother to the wife, in other words, wife's mother, to wife was made to wife only. That in itself evidences a gift. That's number one. And then secondly, and you'll look, if you look at Volume 2, pages 75 through 85, it's my client's explanation of what happened with that check. And this was a check for about $133,500. And then we know that later she added this $15,000 marital funds to it to make it a higher number when the annuity was purchased, or husband did. The second thing that's important is in that testimony, wife said, I just gave it to husband and said, here, deposit this. And there's nothing else about that, just candidly with this court. So what husband did is husband made his own decision to go deposit it into the joint account. And these parties had more than just this one checking account. They had all kinds of investments and you name it. After he put it in the joint account, husband, according to wife, chose to buy an annuity with it. So that was put in both names. By the way, you'll look at Exhibits 9 and 10. Exhibit 9 is the check I've been speaking of. Exhibit 10 is where it was deposited into the joint account. So he bought this annuity. Nothing happened, to answer your question, Your Honor, nothing happened to that. No one dipped into it or anything before that annuity matured on its own, even though the timing of that was very near to when these parties separated and ultimately my client filed divorce. It matured, and that's when my client took that same money out and put it in a separate account, not a joint account again, put it in a separate account where it stays till this day. So that's the kind of the timeline of that. Now,
Excuse me for interrupting, Counsel.
yes, Your Honor.
At the time that the $134,000 was deposited into the joint account.
Yes, sir.
Did the parties maintain separate accounts or individual accounts, or was that the only account that the parties had at that time?
Again, that was the only checking account that they had, and it was a joint account. Yes, Your Honor. And then again, husband chose to take that same money out of that account and purchase an annuity in his and her name together. And again, no one touched it until wife, when it matured, withdrew the entire amount and placed it in a separate account, literally for safekeeping, if nothing else. But again, that was before the divorce was filed, but after the parties separated. What's very important about the potential outcomes of this case is if the court sides with the appellant and reclassifies these funds, which amount to about $160,000, as marital property, it's going to have a snowball effect on the rest of the division. I think Mr. Chancey mentioned this, that it would have an effect on what's equitable. So if you make it marital, let's say that's about $80,000 each, and the court decides to, or you have the court or instruct the court, this probably should be divided equally or equitably, which might be equally, then that's not going to make the rest of the estate equitable. And one of the examples of that is that the court, for some reason, and we didn't appeal this ourselves, but you need to know this in coming up with what's equitable globally, not just on one issue. The trial court gave my client only 40% of the house proceeds, and the house is to be sold and divided 60% to husband, 40% to wife. Interestingly, the difference in 60 and 40% on the assigned value of $400,000 is $80,000. That's the same number that the court has given my client as half of separate property. So it'll skew everything else. The other effect that it could have on the remaining judgment is that the trial court mentions this. On page 9 of its ruling, the final decree, says the court, however, the court's distribution of the marital assets above taken together, and I'm speaking of the 60-40 division, the court's distribution of the marital assets above taken together with the court's conclusion regarding the annuity weighs on both wife's need and husband's ability to pay. So there's the snowball. It's going to affect the alimony award as well, because as we know, what your separate estate is can have a bearing on what your ability to support yourself is. So if there's a change in the dynamic of what this trial court is supposed to do, it shouldn't just be make this one thing equitable. It's make sure you make everything equitable if that's what if you should touch the first part. And so that's a very significant issue that shouldn't be omitted. I do want to point out that there were some omitted facts that we put in our brief that this court should know. And I think Mr. Chancey did touch on these, but one is that this was an abrupt end to a long-term marriage, as we know. And it was regarding the disclosure and charge of sexual abuse, and it did ultimately come out in the form of a criminal indictment. And this fellow is on the sexual offender registry. This isn't just an allegation, as it was implied. This not only broke up husband and wife, it created the loss of the granddaughter's relationship with husband and wife, which is significant in my client's mind as the breaking up of those two. This charge compelled my client to move from the marital home into the home of her son, where she stayed for some 3 years while this case was pending. Again, these parties were married, I guess, really when my client was 16 years old. It's a marriage of 56 years. She's had gastric bypass surgery. She has back issues. She retired with husband's approval in 2005, so hasn't been in the workforce for almost 20 years, 2 decades. Addressing the gift scenario or the inheritance scenario, we know that the gift was from the mother of wife, and the court declared it to be separate property. And that not only involves the 133.5 I mentioned, it includes another $29,000 that was the inheritance Mr. Chancey spoke of that my client received directly and that she purchased a vehicle with. That is separate property. I don't know how you can get around that one, but that's the other side of that coin. The standard of review is with the presumption of correctness on this issue as to classification of property. Separate property is defined statutorily, as we know, as property acquired at any time by gift, bequest, devise, or descent. There's no real proof by the appellant against or to controvert that it was from a gift from her mother to her. That's the first gift. I assume they're claiming the second gift would be from wife to husband or to the marital estate. So they're, and I think one of your honors addressed this in your question. Their complaint is commingling, or complaint that it should be marital is that there was commingling, but they wrongfully claim that it could not be traced back to wife's separate property. If it's traceable, it is separate property unless gifted to the marriage, that's number one, or marital estate, or number two, transmuted into marital property through, and this is important, inextricable commingling with the marital estate. The key here is this is not inextricable. This is traceable, as Your Honor asked the question. On that point, the Lang-Schmidt case, as we've all heard many, many times, is controlling. If it can be traced into its product, because we know there's a presumption of it being marital, but that can be overcome. That presumption can be overcome by evidence showing an intent to remain separate. And I think that's clearly what this was. Next, I want to discuss a little bit the alimony factors that have been appealed. A leading case that I've cited in my brief is the Gonzeki, and I never pronounced that correctly, case that states that the appellate court should be disinclined to second-guess spousal support decisions by the trial court. And in this case, my client had $704 or $708 in TCRS benefits from her time as a judicial assistant. And she also had about $1,200 in Social Security. Conversely, husband has an income with his retirements and his CDs and his Social Security and his pension of almost $6,000. I think it's $5,700. So this court rightfully found that my client's ability to earn my client was asking for a pretty large amount of alimony. She showed a shortage on her income and expense statement of over $6,000. The court reduced that to $1,000 a month, finding that would put her income up to $3,000, and that would knock his available income over expenses down to $3,000. So he still had money left after the $1,000 award. Probably not unreasonable. The question is, under the Gonzeki case, is whether or not the trial court applied the correct legal standard and reached a decision that is not clearly unreasonable. The court looked at in futuro findings indicating that, and we've cited that it's justified where there is relative economic disadvantage, and I've talked about that rehabilitation is not feasible, and where reaching a comparable standard of living is not feasible with reasonable effort. I've cited the factors on alimony. They're all in my brief on page 11. Won't go through all those, but one that appellant brought up was that the court maybe wrongfully used fault as a factor, and we all know from case law that fault should not be used as a punishment, number one, in alimony, but that it is a factor and it can be considered, although it's not high up on the chart like need and ability to pay are. I think if the question that Mr. Chancey said struck him, that affects how unusual the fault is in this case. Not in my wildest dreams. And then here goes this 56-year marriage down the drain. So I don't think the court unreasonably used fault when he, the trial judge, lowered the requested amount from $6,000 to $1,000 in futuro. There are a couple other issues in our brief. We do ask for attorney fees on appeal. They were not granted on at trial. And again, I go back, if that marital asset, or if that money that my client says is separate and the trial court said is separate, is turned into marital, that reduces her ability to pay her fee. If it's divided and he gets part of it and she gets part of it. So we are asking for attorney fees on appeal. And also I think there was a sub-issue about the appellant's ability to petition the court in the future based upon change of circumstances. That's in the law. That's clearly there. I'm not real sure that I follow the reasoning on why that's an issue here, but he can always file a petition to modify on that point. I do want to point out that the trial court did use a little bit of we had a master asset list, let's say it this way, attached to the final decree, but the trial court itself created its own little table, and I think Mr. Chancey has copied that into his brief, but it shows the percentages of the things that remained contested for the judge to make his decision, and that's where I was referring to the fact that of the marital residence, for some reason, the trial court gives her 40%. And the only thing I can think of, just candidly with the court, is she didn't live there and maintain the house for the years after the separation. Again, about a 3-year divorce. And I guess the court found that he should receive more of the marital equity than she should. Unless the court has questions, that's my argument.
I hear none. Thank you very much, sir.
Thank you.
Your rebuttal, sir.
First of all, Your Honor, if I created the impression with the court that I was disputing that this was initially a gift to the wife, I apologize, because that is certainly not my intent. I think it was a gift to the wife by her mother initially. That's not our issue at all. Our issue is, did it become part of the marital estate? And did the court err when it made a decision that this was separate property? I will go back to the question that was asked a moment ago, and that is, anytime separate property is placed into another asset, it's theoretically traceable back. But that's not really the issue. Traceability is one factor that the court looks at. The question, when you consider all of the factors the court has to apply, is, was there an intent to keep it a separate property? And that's what we suggest is absent from the record in this case. With respect to the alimony issue, we do not argue to the court that the trial court could not impose an alimony obligation. Rather, what we're concerned about is that the court did it on a speculative basis. Parties provide, the two primary factors that the court has to consider in an alimony award is need and ability to pay. The wife had been living with one of the party's children for 3 years. She conceded that the child hadn't asked her to leave, and probably wasn't going to happen. She says, I would like to leave. And then she speculated about what it would cost her if she left. And the court then made an alimony in futuro award on that basis. We don't think that's the appropriate application of the facts to the standard involving alimony in futuro. What the court should have done, in our opinion, is perhaps make a de minimis award, and if the wife then came before the court with actual expenses, the court could then revisit that question. And that would be the appropriate treatment for that. Now, the adjustment in the marital estate is certainly a factor that the court would have to take into consideration when it makes an alimony award, but as I indicated here, the court made a division of the assets that it did treat as marital and gave the wife 62% of those. That may be supportable under the law. We're not arguing that the court was bound to do a 50-50 determination here. We're simply saying that you have to put all of the assets in the pot, so to speak, when you make that determination. And $165,000, $170,000 is a significant subtraction from that pot in this particular case. And so if the court puts that back in and directs the court either to make a specific division or to go back and revisit the factors and make another division, at that time the court can consider the alimony issue at the same time if the wife has actual expenses that she can document at that point. Does the court have any other questions?
I hear none.
Thank
Thank
you,
you very
Your Honor.
much. Again, I would like to thank these parties also for your contribution and your presentation. And at this point, your case has been submitted to this court for resolution. You should receive our opinion and judgment within a short period of time. Thank you again, and you may be excused. Mr. Clerk, will you recess court for this afternoon?